as lawyers and as students, law students. So, in a nutshell, I want to do a short talk because I believe that this is both informative and also educational, and I will expect, especially the law students, to interact, ask questions, and let us have a very informative and learning process today. So, like you already saw, my topic today, it's titled, I'm narrowing down my theme to focus on the audience, law students and lawyers to be, and also professionals, the academia, legal scholars who might find it interesting. So the title is Law Schools and on Academic Originality in the AI era. I mean, you see, because we are scholars, we have kind of license to mess with English words at times. Because I'm sure if you go to Google or Chat GPT, you won't find a word like unacademic. Or, but it paints a picture of the core of my presentation. Now, you see, AI, as we all know, is a disruptive system. If you've listened recently to the news, about 2 days ago, AI interrupted global economy. AI interrupted money. Billionaires had a lot of high blood pressure. People were scared. Government was scared because stocks dropped. A new entrant, DeepSeek, which is an AI system, interrupted the whole situation. I mean, the allegation now is probably there is AI, intellectual property, infringement, and all that, which we're going to talk about. It's part of the talk here. But it shows you how relevant this technology is. How relevant is this technology when it concerns law schools, law students, legal academic, legal scholarship? Now, my topic is focused strictly on intellectual property as it intersects with AI. Now, I'll narrow it down to the issues of copyright. Now, we talked about originality. Now, if you are students of copyright, you will realize that you should know by now that AI is a computer program. Even the Indian law, because India is part of WIPO, American law, Saudi law, globally, computer programs have been recognized as literary works, meaning that copyright is the controlling, I use that word with emphasis, the controlling jurisprudence, the controlling law, the controlling regime that regulates anything that is literary. Meaning, so in the space of AI, there are other laws that regulate it, but I'm talking, when I say control, means at the apex, at the jurisprudential hierarchy, the pyramid, it is copyright that stays at the top. Meaning that until you fulfill the legal requirements of copyright in terms of a literary creation, that is when copyright can either protect your literary work, meaning your legal writing, because legal writing, scholarship, what you're going to publish. As lawyers, we are taught that oral presentation and legal presentation are the blood of a lawyer. I mean, it is your tool. If you are not a good writer, if you are not a good speaker in the tool of your trade, in law, whether you are an academic, whether you are practicing, whether you are a judge, you will find it very difficult to be a successful lawyer. And because law and academic ethics, academic integrity seems to collide, they seem to have a little bit of friction Because the law requires that before your writing, that's copyright law, qualifies as a thing that could be protected, it has to fulfill certain eligibility metrics. And I'm glad that in India has made it even easy, because India seems to follow the global trend in the Supreme Court case, which I'm going to talk about a little bit. I think there's a Supreme Court case in India that has now clarified the standards of originality. DB, Modak, and another. I think it's a 2008 case. So you see, that is how important for us to study and understand that in academia, apart from the fact that you've been given certain privileges as students,